Hello, my name is Taylor White. I will be discussing the Violence Against Women Act, which is usually referred to as VAWA, B-A-W-A, and which I will also be referring to as VAWA throughout this presentation. After dealing with violent victimization, women may want to seek legal help through the criminal justice system. This can include immigrant women, battered women, Native women, sexually victimized women, or any woman who has violently been victimized in her lifetime. The focus of my research is to examine just how the Violence Against Women Act has been used in court cases to defend women as such. Throughout my research, I learned that VAWA is the first federal law on gender-based violence. Mind you, VAWA was enacted in 1994, and this was the first federal law. It recognizes and strives to stop violence against women, which indicated the effort by Congress in addressing this brutal problem. Before VAWA, states didn't think of domestic violence as a public problem. Rather than a public or a state problem that involved the criminal justice system, it was more so you kind of dealt with it within the family. Mind you, women did report to the police. They did go through the justice system. It just wasn't as effective, efficient, or taken seriously as it has been since VAWA has been enacted. Since VAWA has been enacted, the criminal justice system now treats domestic violence like any other violent crime. It has also provided more services such as victim services, counseling, and shelters for women. In my research, I used case analysis. There were two search engines that I utilized. These engines included Westlaw and Google Scholar Cases. The two keywords that I looked up in these search engines were VAWA and the Violence Against Women Act. When looking through the cases, I wanted to provide diversity rather than the outcome, just to show how VAWA can work for different women in different situations and scenarios and in different courtrooms. Showing how effective VAWA is in diverse situations, I think shows how efficient VAWA can be compared to the outcome. The four cases I chose either involved child pornography, rape, or battered immigrant women. There is one case I want to get a little more into detail about. It involved an immigrant woman. Her name was Wenkin Sun. She is a native from China and also a battered spouse. Sun originally sought asylum from the BIA, or the Board of Immigration Appeals, to get away from her abusive husband. The BIA denied asylum, which is why in this case that I analyzed, Sun sought review of the BIA's denial of her motion to reopen removal proceedings on the basis of her successful application to qualify for an adjustment of status under VAWA. This was all due to her errors of counsel in the first runaround with the criminal justice system. The judge in this new appealed case that I analyzed granted Sun's petition, allowing her to seek asylum, which she should have received the first runaround with the justice system. After looking at each case, I found all the cases involved VAWA, but only some completely relied on it. Others used VAWA, but they also used other laws and cases to support the victim. Another thing I noticed was that in each case I analyzed, the judge sided with the victim, thus meaning the victim received justice or restitution. Lastly, one more thing that I realized between these cases is that the victim and the judge both used VAWA. The judge either made a decision based on VAWA, or the victim brought the decision into court using one of the sections in VAWA to defend themselves. These four cases show how VAWA can be applied in different contexts. We see this by VAWA aiding each woman in a specific way to provide them a restitution or justice. Overall, VAWA is portrayed as a positive aspect in court cases when victims choose to utilize it. This research shows that victims who rely on the justice system can ultimately rely on VAWA for justice as well. Thank you.